Dr. Horton, a consultant emergency physician at Chesterfield Royal Hospital NHS Trust, faced allegations related to unlawful racial harassment and victimization under the Equality Act 2010. The allegations stem from an incident in November 2020, where Dr. Horton allegedly made derogatory comments about a colleague, including a statement about Mexicans shagging donkeys. The doctor colleague responded with a similar comment about English individuals. It was disputed who made the comment first. Additionally, Dr. Horton was accused of writing donkey shagger on a label and attaching it to a water bottle he believed belonged to the same colleague, then showing it to Dr. A in a public area. This led to the victim filing a formal racial discrimination complaint against Dr. Horton. The complaint was investigated internally by the trust, which concluded that Dr. Horton's concerns about Dr. A and Dr. Horton's counter-complaint were unfounded. Dr. Horton, who was on leave at the time, claimed that his subsequent actions were unrelated to the complaint. During the facts stage of the hearing, several applications were made and outcomes were determined by the tribunal. The tribunal granted the GMC's request for Dr. Horton to turn off his camera during Dr. A's testimony, and this was not contested by Dr. Horton's counsel. Additionally, the tribunal approved the GMC's application to introduce a witness statement and exhibits from Ms. E into evidence, as it was deemed relevant to the case and would not prejudice Dr. Horton. The tribunal partially accepted the GMC's request to admit exhibit based on the content of Dr. H's witness statement, with only relevant portions being allowed. There was opposition due to some content's lack of relevance. Both parties agreed to admit a letter of concern from Dr. Horton dated the 8th of April 2021, with specific redactions. The GMC presented witness evidence in written and oral forms during the hearing. Witnesses for the GMC included Dr. A, locum consultant in the ED at the Trust, lead medical workforce coordinator, HR advisor, clinical lead in the ED, and a senior staff nurse, among others. Written statements were also provided by witnesses not giving oral evidence. Dr. Horton presented his own witness statement and gave oral evidence during the hearing. Additionally, a colleague who is Fellow of the Royal College of Emergency Medicine with dual accreditation in emergency medicine and pediatric emergency medicine provided both written and oral evidence on behalf of Dr. Horton. The tribunal's approach in determining the facts of the case was guided by the relevant legal framework, particularly sections 26 and 27 of the Equality Act 2010. The tribunal acknowledged that the burden of proof rested with the GMC, employing the balance of probabilities standard. The tribunal had the responsibility of evaluating the credibility, reliability, and weight of the evidence, while ensuring fairness by providing reasons for decisions when necessary. In relation to the allegations of harassment and victimization, the tribunal considered the definitions provided by the Equality Act 2010. The legally qualified chair provided legal advice on these definitions and outlined the relevant case law. The tribunal addressed various aspects, including unwanted conduct, inherently unwanted conduct, situations where conduct isn't objected to, and the approach to gray areas. The LQC also explained the case law guidance on what constitutes a detriment and the concept of causation. It was emphasized that the real reason behind the treatment, considering both conscious and subconscious motivations, should be established rather than a strict but for test. This approach ensured a comprehensive assessment of the conduct alleged in light of the legal framework and relevant legal precedents. The tribunal carefully analyzed each paragraph of the allegations separately and evaluated the evidence to arrive at its findings. In relation to paragraph, which involved the comment made by Dr. Horton about Mexicans and donkeys, the tribunal found that Dr. Horton did indeed make such a comment based on his admission of writing the words donkey shagger on a water bottle belonging to Dr. A. However, the tribunal assessed the context of the conversation and workplace culture. Dr. A, of Mexican heritage, responded with a similar comment about the English and sheep. The tribunal concluded that the comment made by Dr. Horton was related to race due to the association made with Mexicans, and it assessed whether this was unwanted conduct. Considering the department's culture of banter and the nature of the relationship between Dr. A and Dr. Horton, the tribunal determined that the comment was not wanted conduct and remained unwanted. Although the comment was found to be inappropriate and offensive, the tribunal believed that Dr. Horton's intention was not to cause a prohibited effect, as he had poor social skills in such matters. While the comment offended Dr. A, the tribunal found that it did not create an environment that violated Dr. A's dignity or was intimidating, hostile, degrading, humiliating, or offensive. Dr. A's reaction indicated that he considered it a poorly executed joke and did not raise a complaint at the time. The tribunal evaluated the events described in paragraph 2b of the allegation, which involved Dr. Horton approaching Dr. A and mentioning the labeled water bottle with the words donkey shagger. Dr. A's version of events was consistent with his initial statement, and Dr. Horton's own admission of labeling the bottle aligned with Dr. A's account. The tribunal found it likely that a conversation about the water bottle did take place in the corridor. As for the legal assessment, the tribunal determined that the comment, "Oh, have you seen your bottle? I've put a label on your bottle," donkey shagger was related to race and constituted unwanted conduct, similar to the previous interaction. Despite the repetition and offensiveness of the comment, the tribunal found that it did not have the effect of violating Dr. A's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for him. Dr. A's reaction indicated that he initially found it funny, and only upon discovering the labeled bottle in a public area did he consider it to have crossed a line. The tribunal concluded that while the conduct was inappropriate, it did not reach the threshold required to establish unlawful racial harassment under the Equality Act 2010. The tribunal examined the events described in paragraph 2A of the allegation, where Dr. Horton attached a label with the words "donkey shagger" to a water bottle he believed belonged to Dr. A. Dr. Horton admitted to this action and explained that he intended the label to be found by Dr. A. Dr. A, upon discovering the labeled bottle, felt deeply offended and believed he was being paraded through the department as a result of the label. The tribunal determined that Dr. Horton's action was unwanted conduct and a continuation of the conduct previously found to be related to race. While Dr. Horton's intent was not to create the prohibited effect under Section 26 of the Equality Act 2010, the tribunal concluded that Dr. A's response was reasonable. Dr. A had previously shown resilience in dealing with Dr. Horton's inappropriate behavior, but this instance crossed a line, creating a humiliating, degrading, and offensive environment that violated Dr. A's dignity. Consequently, the tribunal found that this conduct breached the provisions of the Equality Act 2010. The tribunal has determined the following facts concerning Dr. Horton's conduct. On or around November 24, 2020, while working at the trust, he approached Dr. A and made discriminatory remarks as. On or around November 26, 2020, while working at the trust, he attached a label with offensive words to a water bottle he believed belonged to Dr. A. He approached Dr. A and made discriminatory remarks. His actions constituted unlawful racial harassment, violating Dr. A's dignity and creating a hostile environment. Between January and February 2021, Dr. Horton spoke to Ms. B and raised concerns about Dr. A's compassionate leave being inaccurate. Expressed the desire to raise the concern anonymously due to an ongoing investigation into his own conduct. Mentioned Dr. A's fitness to practice record. On February 9, 2021, Dr. Horton spoke to Dr. C and raised patient safety concerns about Dr. A's working shifts at multiple hospitals. Requested information regarding Dr. A's working patterns. Mentioned Dr. A's fitness to practice record. On February 10, 2021, Dr. Horton emailed Dr. C, raising concerns about Dr. A's compassionate leave claim. Around February 15, 2021, Dr. Horton provided Dr. D with information about Dr. A's past working shifts at Airedale Hospital. Dr. Horton's conduct as described constituted unlawful victimization under Section 27 of the Equality Act 2010, as he subjected Dr. A to detriments due to Dr. A's complaint against him. The tribunal will determine whether Dr. Horton's fitness to practice is impaired as a result of this misconduct. During the determination on impairment, the tribunal considered the evidence presented during the fact stage, including Dr. Horton's continuing professional development, testimonials, and a reflective statement prepared by him. Counsel for both sides made submissions on whether Dr. Horton's fitness to practice was impaired due to the misconduct findings. The counsel, representing the GMC, argued that the proven facts amounted to serious misconduct, breaching professional standards and damaging public confidence. She referred to relevant case law and good medical practice guidelines to support her argument. She highlighted Dr. Horton's limited insight and his tendency to portray himself as a victim. She asserted that a finding of impairment was necessary to protect public confidence and uphold professional standards. The defense counsel, on behalf of Dr. Horton, conceded that the behavior described in the allegations was inappropriate and unacceptable. He argued that while the behavior did constitute misconduct, it might not reach the threshold for serious professional misconduct. He contended that Dr. Horton's repeated apologies, recognition of impact, attendance at remediation courses, and lack of prior and subsequent similar behavior demonstrated insight. The counsel also distinguished between discriminatory behavior and concerns about patient safety, emphasizing that the former did not directly jeopardize patient safety. The defense further highlighted Dr. Horton's engagement in CPD, his experience through investigations and the hearing process, lack of similar concerns before or since the incident, and his commitment to avoiding similar conversations. He suggested that Dr. Horton's behavior during the earlier allegations might have been influenced by his health at the time. The council acknowledged the public's expectation of a finding of impairment for the later allegations. In summary, the tribunal considered the arguments and submissions regarding the seriousness of the misconduct findings and whether they warranted a finding of impairment for Dr. Horton's fitness to practice. The tribunal proceeded to determine whether Dr. Horton's actions amounted to misconduct. They reviewed the admitted or proved facts and considered the seriousness of each set of allegations. The tribunal found that Dr. Horton's comments and actions constituted unwanted conduct related to race. The tribunal noted that the legal standard of racial harassment was met. The tribunal also noted that such behavior, even in the form of banter, is unacceptable, and Dr. Horton's actions in this context were considered unprofessional. They stressed that his senior position should have set an example for the team, and his actions nurtured a potentially harmful culture. The tribunal determined that Dr. Horton's actions were designed to discredit Dr. A, not just within their immediate environment but also within the wider profession. This conduct aimed to obtain information for Dr. Horton's own benefit in response to the complaint raised against him. The tribunal found this behavior to be a significant departure from the required collegiality with colleagues and considered it could deter others from raising concerns. The tribunal emphasized the importance of the ability to report matters without fear of retribution. Overall, the tribunal concluded that Dr. Horton's actions amounted to serious misconduct. They found that his conduct brought the medical profession into disrepute, eroded public trust and confidence in the profession, and breached fundamental professional standards. As a result, the tribunal determined that all the proven matters constituted serious misconduct. The tribunal moved on to determine whether Dr. Horton's fitness to practice is currently impaired as a result of his serious misconduct. They considered the aspects of remediation and insight regarding the allegations. The tribunal acknowledged that Dr. Horton had expressed remorse, apologized, and participated in various courses. However, they found that the courses he took did not sufficiently address the issues identified by the tribunal. While his insight had improved to some extent, it was not yet complete. The tribunal noted that Dr. Horton needed to further understand the implications of his actions and their impact on others, particularly in terms of racism and discrimination. The tribunal concluded that while the risk of repetition of his actions was low, Dr. Horton had not fully gained insight into his conduct's impact on others, including the victim. They emphasized the importance of doctors understanding the rights of all individuals, irrespective of protected characteristics, to raise concerns without fear, as this is essential for maintaining patient safety and professional standards. Considering the overarching objectives of protecting the public, maintaining public confidence in the medical profession, and upholding professional standards, the tribunal found that even though Dr. Horton had taken steps toward remediation and insight, the seriousness of his misconduct necessitated a finding of impairment. Consequently, the tribunal determined that Dr. Horton's fitness to practice is impaired due to his misconduct. The tribunal proceeded to determine the appropriate sanction to impose on Dr. Horton in light of the findings of misconduct and impairment. Both parties presented their submissions on the matter. The council, on behalf of the GMC, argued that a suspension would be a suitable and proportionate sanction. She highlighted the seriousness of Dr. Horton's misconduct, his journey towards insight and remediation, and his positive career history. She also noted mitigating factors such as his lack of disciplinary history and the potential impact of COVID-19 on doctors' behavior during the pandemic. The council, representing Dr. Horton, concurred that a suspension followed by a review would be appropriate. He suggested that a shorter suspension period, such as 1 or 2 months, would be sufficient given Dr. Horton's intent to return to work and dedication to remediation. Aggravating and mitigating factors were taken into account. The tribunal identified the repetition of Dr. Horton's inappropriate behavior over multiple days and his attempts to undermine Dr. A as aggravating factors. They also noted his remorse, willingness to remediate, and positive character as mitigating factors. The tribunal analyzed various potential sanctions, starting with taking no action, but concluded that this would be inappropriate due to the seriousness of the findings. They then considered imposing conditions but determined that these would not be workable or proportionate in this case. The tribunal moved on to assess the option of suspension. They referred to relevant parts of the sanctions guidance and noted that suspension might be appropriate when a serious breach of professional conduct has occurred but isn't fundamentally incompatible with continued registration. They also highlighted the importance of treating colleagues and patients fairly, and the serious consequences of discrimination. Considering Dr. Horton's progress towards insight, his previous good character, and the risk of repetition, The tribunal concluded that a suspension would be an appropriate and proportionate sanction. They believed that this would protect the public interest while allowing Dr. Horton time to further develop his insight and understanding of the impact of his actions. This suspension would also send a clear signal to both him and the profession that such misconduct is unacceptable. In the tribunal's view, the circumstances of the case didn't warrant a more severe sanction, as Dr. Horton's conduct, although serious, was not fundamentally incompatible with maintaining his registration. The tribunal deliberated on the appropriate duration of Dr. Horton's suspension in line with the overarching objective. After careful consideration, the tribunal concluded that a 4-month suspension would adequately reflect the seriousness of his misconduct and convey a clear message to Dr. Horton, the medical profession, and the broader public that such behavior is unacceptable from a registered doctor. The tribunal also took into account the potential impact of suspension on Dr. Horton's skills. They directed a review hearing to be held shortly before the end of the suspension period. During the review, Dr. Horton will bear the responsibility of demonstrating his developed insight and remediation. The tribunal outlined specific areas where evidence would be beneficial, such as ongoing continuing professional development, his understanding of the tribunal's findings, his awareness of perception by others, and coping strategies for similar situations or future complaints. Both parties agreed that an immediate order was unnecessary, and the tribunal concurred, choosing not to impose one.